me know when you're ready, Mr. Champion.
Thank you.
Yep.
We're ready to proceed.
Thank you. We are back on the record for People versus Lilleberg. The court recognizes joining me today now is Mr. Bob Champion, Robert Champion, the defense counsel, as well as the defendant who is currently in pre-trial custody. Or, I'm sorry, post-conviction custody here in Missaukee County Jail. Before I turn it over to counsel, let's take a look here. Ms. Odell, on CFJ 145, page 3, it lists her credit dates or days 269, but I don't see those listed underneath CFJ 145, page 1. It just lists 0.
Apologies, Your Honor.
That's all right.
Fix that.
Take another look here to see if I see anything else. Mr. Denham on CFJ 284, page 15, or 14, carrying on to page 15 for entry 15 of 16 in this Lilleberg's criminal history. There's this other case down here. Is that still pending?
It is, Your Honor. The final pretrial is scheduled for this coming Wednesday, Your
All
Honor.
right, I figured it was. I just wanted to double check to make sure nothing had changed since we got in this report.
Your Honor, it's fair to say on that case will be dismissed.
All right, that's kind of what I thought. Maybe at one time somebody had told me, but
Yeah, I don't want to, I guess, anticipate what's going to occur today, but depending on what occurs today,
Right.
it's highly likely, Your Honor.
okay. All right, thank you. All right, I don't see any other corrections. Mr. Denham, how about you? Do you have any corrections, amendments, objections to be made?
Yes, Your Honor. With respect to the scoring on all of the offenses, the people believe that PRV 6 should be scored at 10 points rather than 0 points. I think the confusion in this case was that there was an understanding that when the officers, the deputies went out, that they were serving the arrest warrant for that other case, when in fact she had already been arraigned in that case and they were serving a bench warrant for that case.
Oh, okay.
So that's why on all of the offenses, it should be 10 points. It's my understanding that it does not change the scoring. Here.
All right. So that will, any objection to that, Mr.
No, Your Honor.
Champion? Thank you. So yeah, that's going to, we'll go ahead and make that change for PRV 6 on each one of the SRI 88-1s. That's going to make the total PRV go from 95 to 105, which at least, yeah, for all of them, which still maintains a PRV level F as in Foxtrot. All right.
You're along with that, just in the wording on CFJ 284, page 4. I believe it is 5 paragraphs down. It just, there's language to the effect that the deputies were out serving an outstanding felony warrant. So if we could just make that wording change as well. Thank you.
That's fair. Go ahead and make those changes, Ms. Odell. Do you know what we're talking about?
Yes, Your Honor.
All right, great. Thank you. Mr. Champion, any amendments, corrections, objections tonight?
Your Honor, corrections to this matter on CFJ 284 on pages pages 2 and 3, it indicates underscoring of OV-19 that my client made threats that she would kill them. The testimony at trial from my client is that she was asking them not to kill her in this situation, and she denies that she made that statement.
What did the Mr. Denham, what, I don't recall on this specific point,
Well,
what was testified to. I do remember, I know Deputy Wetzig and who's the other deputy? Hold on. Seiler. I couldn't remember exactly what they said. I do know she had the hammer thing. Go ahead. Yes.
So the testimony, I believe it was from Deputy Wetzig, was that when he went inside of the RV at the very end of the chase, that when she went in from the driver's seat to the back bedroom area, the door was shut, and the testimony was that he heard her say that words to the effect that I'm going to kill you, or words to that effect.
Yeah.
But I don't think the scoring was limited based upon that testimony.
Well, no, it's not really that. I know, for instance, on with the assault with dangerous weapon charges, those had to deal with the hammer and so forth. So let me go back and take a look, CFJ 284 page 6. And I'm looking at the scoring of OB 19. Yeah.
This was a situation where that wasn't a dispute. I believe the deputy couldn't specifically say, we listened to it several times on video to try to clarify it, and it was unclear of exactly what was said.
Yes, sir.
Your Honor, even if we struck that language, I would have no objection. I think that there's an independent basis to
Sure.
score OB 19.
There is, I agree. All right, we'll go ahead and strike those.
Thank you. With that, we have no other additions, corrections, or deletions.
So again, Ms. Odell, at the end of offense verbal 19 scorings, wherever it says, quote, and stated she would kill them, end quote, we'll just take that out. All right. Do we have any, I don't see anyone here. Do you have any victim impact statements that I need to entertain today, Mr. Denham?
We do not, Your Honor, but along those lines, we were just going to ask for 30 days to leave open restitution for Keith Puffer. We've been unable to have communication with that individual, Your Honor. That was for the well in the mailbox.
The wellhead, or is a wellhead? I mean,
Yes.
Wellhead. Wellhead.
Yes, Your Honor, just 30 days, just to, we have made attempts, Your Honor.
Okay. All right. Anything else? Any other, I'm sorry, allocution then, Mr. Denham?
Your Honor, the guidelines in this case for the felonious assault, 14 to 58, the recommendation is for the higher end of the guidelines. We do support that recommendation. We would ask for the defendant to be sentenced as a habitual fourth offender. We would note that the defendant does have 2 prior MDOC commitments. At the time of the offense, as has been indicated, there was a bench warrant out for a failure to comply. The recommendation is in line with the assessment, which indicates that Ms. Lillyberg really needs long-term cognitive behavior programming, so we should think it would benefit her. The court is well aware of the case. We obviously had a jury trial, but just very briefly, it involved when the officers went to the scene, kind of locked the door, drove away, damaged the wellhead in the mailbox, backed up several times, almost hitting the deputies. During the course of that, there were strike strips that were deployed. There was a taser that was out, a screwdrivers, plural, were used. A hammer was thrown. And I guess the focus that I would really like to emphasize is how long of a chase this was. This was 47 minutes. It covered approximately 8.7 miles. And fortunately, no one was seriously injured, but because of the circumstances that resulted by Ms. Lillyberg's actions, this was a very serious incident where any number of motorists potentially could have been injured, where the deputies could have been injured, or Ms. Lillyberg herself could have been significantly injured. I think that the deputies showed amazing restraint in the limited force that was used. I think they could have used additional force that would have been justified, but she herself was in significant danger by her own actions. So with that, we would respectfully request that the court follow the recommendation of the probation department.
Mr. King.
Thank you, Your Honor. When we look at this report, and we look at my client's history and trauma that she has suffered throughout her life, starting at a young age, it does give us some insight of what happened on this day, given her, as the report says, dysfunctional, chaotic, and transient upbringing in this matter. My client would acknowledge, due to the trauma that she's received or has been a victim of through the course of her life, that her reactions sometimes are not logical. It's a situation of fight or flight, and it doesn't make sense, as we saw in the, my client, without question, is asking for treatment, is asking for help. And I think this situation was a demonstration of looking for help, trying to figure out where to go and what to do with her life. She's been the victim of some horrendous situations in this matter and continues to vocalize to anyone that will listen what has occurred to her and the trauma that she has suffered. So with that, Your Honor, I would ask the court to consider the bottom of the guidelines in this matter with probation. Thank you.
All right. I should have, if I didn't already, acknowledge that I did receive a mitigation report prepared and submitted by the Public Defender's Office. I did read through it and I wrote notes, so I'm very well aware of what challenges she has had in her life, and difficult life experiences that have colored her perspectives and how she approaches life and deals with challenges. And I quite honestly have a great deal of sympathy for her based upon those. I won't discuss them any further. I'll just say for the record, I consider them, and they're contained both in the PSI and again, that mitigation report. Ms. Lillenberg, you have the right to make a statement if you choose to do so. Or is there anything you wish to say at this time, ma'am?
I just want to say I'm very sorry, Your Honor, for my actions, that I have learned a lot through this, and I regret what I did very, very much so. I don't want to justify it. I was under a lot of stress and there was some bad circumstances that I was going through. And I had a bad incident with that police officer prior to that. And I was scared, Your Honor, and I know what I did was very tremendous and it was very wrong.
All right. Well, the court's going to go over, as it must, the contents of the report, which it's going to consider at sentencing. Here, just a moment. I've written down here several times in this report when it came to the defendant's description of the offense. And what I wrote down, it sounds rude. I don't mean to it. I write it down so I kind of reference. And I'm very sorry for the things that you've dealt with in your past and how it's probably created a lot of scar tissue on you and your emotionally, and how it impacts your ability to make decisions maybe. But at the same time, those are not an excuse, and they aren't relevant to me today. I mean, I'm sorry, they have a very limited relevance to me today, because none of them justify at all what you did. The officers didn't pull firearms on you, guns on you. They didn't even get to lay hands on you till after a 47-minute a 47-minute 9-mile. I called it a slow speed chase. Thank God it was late at night, early in the morning, however you want to look at it, in the middle of the night. And you were going relatively slow. You were chucking stuff out the doors and the windows and throwing things out. You'd stop, get back up, you'd try to ram the squad cars, you try to back up when the officers were out there on their foot. They never even got to the door of the vehicle. They tried to get you to stop. They threw out spike strips that sometimes even got caught in the tires and then later on fell off. And you would get to intersections and turn around, and I don't know what you were thinking or doing. You were driving. The officer showed a great deal of restraint. I mean, your conduct was quite dangerous. I was pointing to Mr. Dennell because that's the word he used. A great deal of restraint. It was almost like watching a Monty Python episode. And I don't mean to say that to be rude, but nothing that they did justified your response. And so I know you've had these experiences with this person whose house you were staying at in this RV, but I'm going to say something because I don't know what you think or feel every day based upon the things that happened to you as a child. And I deal with those cases a lot too. You've got to stop. Stop using these excuses. Whenever I have a case where I sentence somebody who's a defendant on a sexual assault with children, I look to the kids and say, listen, this isn't so much about your forgiveness. It's about you taking power and control over your life. Well, you're not exercising any control over your life. And I don't know what it's going to take. I can't let that history be a justification for too light of a sentence, because I suspect that's been brought up every time you've had a conviction in the last 20 years. You've got quite a few for a person who's of your age, 44 years of age. You had a couple as juveniles, which they had to deal with crimes of dishonesty. Operating without a license was one, retail fraud. You know, and I'll go back. Before I go back to criminal history, in your defendant's description of the offense, you didn't talk at all about what happened that night. It had nothing to do with the description of the offense. You talked about how some other people should be charged, or other crimes having nothing to do with this night or this activity. None of it had anything to do with what the activity was. It was all excuses. I'm going to encourage you, please take a hold of your life by stop making excuses. You're always going to have those experiences in your past. You can't undo them. You can only control you and your choices. And so far, for the last 20 years, you've done a horrible job making choices. 2005, you got your third conviction case, but it was your first as an adult. And you got drug houses and marijuana, multiple probation violations, bench warrants had to be issued. And then looks like you were only on probation for 13 of 18 months before you violated that probation back to, well, there's only a conviction for marijuana, but you look at it, it's the same sets of charges, drug houses again, drugs. Your life, oh, by the way, and on CFJ 145, page 1, there is clear evidence that since 1992, your life has been driven by your choices for marijuana, alcohol, and opiates. There's not really anything else missing here. Oh, and by the way, second here, there was a charge for methamphetamine in her past. Wasn't there? No, I might be wrong. All right. Yeah, always to maintain drug houses. So anyways, so back to 2005, you violated probation, picked up more stuff. Looks like you made it 4 months before violating probation again, where you picked up a drinking and driving. Looks like you had about a 2-year gap, and you picked up number 4 of 16, more crimes of dishonesty. Once again, you're stealing. Next one, looks like you made it about 6 months And then you more stealing from people, more probation violations. Then. Oh, Ms. Odell, did you see that?
I do. I'm
Okay.
catching it right now, Your Honor.
Thank you. For 6 of 16, that would have occurred while on probation. You made it exactly 1 month into a 3-month probation sentence before you violated with more stealing. And it didn't last very long before you started violating that probationary term. In fact, in 7 of 16, which was dismissed, there at least was some initiation of an offense allegedly while on bond. But again, that was dismissed. Then in 2011, you're back to more stealing from people, more crimes of dishonesty. And then from here, actually, what I was just mentioning was entry 8 of 16. Well, if I go back and look at 6 of 16 on page 10 of CFJ 284, there are a series of 1, 2, 3, 4, 5, 6, 7. Convictions all going on at about the same time between 2011 and 2012. And several of them are just stealing from people. Unarmed robbery, fraudulent transfers with money, larceny from a person, multiple bench warrants, probation violations. The addition that you went to prison on 1 series of probation violations. In 2000 and what was that? 14? No, that's when you were paroled. In 2013, you went to prison. You actually started off with a 150-day jail sentence, and you couldn't stay out of trouble, so you ended up having to go to prison. 12 of 16 occurred while on bond for another case. More dishonesty stuff with driving without a license or having multiple licenses. 13 of 16, you violated bond and picked up another set of charges, and it's a repetitive one, operating without a license or a valid license. And then 2015, you pick up entry 14 of 16, and that's a relatively long list. This is what we get. We had delivery or manufacture of heroin as a second habitual felony offender. And you had multiple probation violations there. And then you were sent to prison because of those violations. Then you had 15 of 16 in 2024, and that's the one we talked about that's still pending. And now we're here. The officers tried to arrest you on the other file. Yes, didn't open the door. All your yelling back and forth about, I'm going to get to it, let go, blah, 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 was just a ruse as you were trying to get the vehicle started so you could rocket off the blocks and take off driving down across the field, across the yard, out into the roads. You went 8 to 9 miles all over the county, throwing stuff out. You even stopped one time to throw a dog out. I mean, you didn't throw, but you slow down, you tossed a dog out of a car. Your conduct was unacceptable. These officers and the way they handle themselves was a great show of restraint and professionalism. As you drove around like a chicken without a head in charge of a large SUV, or not SUV, RV. So, and again, when it comes here to talking about your crimes, you didn't talk about the crimes, you talked about something everybody else did and started pointing fingers. I'm going to tell you, you've got to stop pointing fingers. You've got to start taking responsibility for your own actions. So the sentence of this court is as follows. The court assesses 6 $68 state minimum fees, a $130 crime victims right fund fee, a $300 court cost, which this court finds is fair and reasonable based upon the processing of the case and so forth.
What was that again?
$300. The court isn't going to assess any fine. I'm going to assess a $300 attorney fee. There is no supervision fee because there's no probation. DNA fees, there was already DNA available. In each one of these cases, the maximum punishment, as the court chooses to sentence the defendant as a fourth habitual felony offender, increases that maximum punishment to a period of 180 months. So therefore, I exercise that discretion. Now, the question is where do I go on the minimum end? And for each one of these cases, I'm going to sentence somewhere toward the middle of the guideline range, definitely be in compliance with that guideline range. And the court sentences the defendant for count 1, 36 to 180 months, count 2, 36 to 180 months, count 3, 36 to 180 months, count 4, 36 to 180 months, and count 5, 36 to 180 months, and count 6, 36 to 180 months. And for each one of those, the defendant receives as jail credit 269 days of credit. You also will receive credit for any of the good conduct time that you've received as well. Have I missed anything, Ms. Odell?
You're just questioning, they're all concurrent to each other.
I'm sorry. Yes, they are all concurrent to one another. Now, of course, we don't know what's going to happen. I don't know yet what happens to the other ones, the other case file. But anyways, that is correct. Have I missed anything, Mr. Denhouten, or any questions, sir?
I don't believe so.
All right.
Can I
Thank
go
you.
back to assessments? Your Honor?
Yes.
There's no fine?
No, I did not put a fine.
Okay, we're reserving restitution 30 days.
Yes.
Thank you.
All right. Mr. Champion, I see has already filled this out. Ms. Lilleberg, Mr. Champion's bringing to me a copy of a document that you should have placed your initials on. And I'm going to hold it up for you. Is that your?
Yes, sir.
All right. This document is about your appellate rights. You have the right to file a claim of right to appeal, which is different when somebody enters a plea based upon a pretrial agreement. Here, based upon the fact that your case resulted in a conviction at a jury trial, you have the automatic right to file a claim of appeal, and the court must hear it. Now, this form that you're putting your initials on doesn't waive any rights, or sorry, putting your initials on it doesn't waive any rights or assert any right. It merely acknowledges receipt of the other copy, which you've already provided back to me requesting the appointment of an attorney. Therefore, the court will have this file process for the appointment of an appellate counsel in accordance with the law. All right. Any questions about your right to appeal? All right. Again, I find that based upon all the factors that I've considered and discussed today, not only based upon the mitigation report, my memory of the trial and watching the videos, dash cams and so forth, as well as the contents of the pre-sentence investigation report, prior criminal history and performances on bond and probation, I find that the sentence is fair, reasonable, and proportionate as to all counts. Thank you. We're adjourned.
Your Honor, one matter.
I'm sorry.
I spoke to the prosecutor. The
Yep.
case will be dismissed.
Sorry?
I
Will be?
spoke to-
Yes, Your Honor, we'll submit a dismissal on that other case.
All right, so thank you. So that means we'll see the under sheriff here. That means we don't need to keep her for the resolution of the other case
Okay,
copy,
thank you.
so you can just transfer her at your convenience. Thank you very much. Now we're.